say you.
And even if the court could appropriately consider the news reports that I was like, even if the court could appropriately consider that, it's a vague representation, along with Trump's vague representation. And yeah, we did terminate a number of people last week. That's not going to cure your deficiencies. So the states were saying, well, what are you going to be able to fire? You don't know? No. Should you know? No, it's not relevant to you under this case at all. You're going to fire 1,000 people or 10,000 people. That's our prerogative, constitutionally allowed. So take it up with someone else. If you've got some basis why you can't. And all these judges, many of these judges are using this as an opportunity to opine on the bench about their fury with what Trump is doing. But that doesn't matter. They can be mad about that. The law is the law. Now, terminating thousands of employees may cause extreme harm to individual employees and potentially to leave the institution, not harm per se, but it is harmful to not behavior to continue. So we have to, right?
Get it out. I'm going to switch over to locals.
To the parties before the court. And the state have not adequately linked Trump and Elon's actions to any imminent harm that the states have in particular. Now, that being said, Judge Chekin says, the states do raise a very colorable appointments clause claim with serious implications. So this is where she's going to throw up her whole opinion. Musk has not been nominated by the president, nor confirmed by the Senate, as constitutionally required for officers who exercise significant authority pursuant to the laws of the United States. Bypassing this safeguard of his constitutional scheme, they say, Musk has rapidly taken steps to fundamentally reshape the executive branch. He's like a consultant. The people who are in charge of those agencies are taking those decisions with the lawful power to do that. Even Trump concedes there is no apparent, quote, source of legal authority granting Doge the power. I like how she just cuts that off. Nice little selective quote there, Judge. Source of legal authority granting Doge the power to what? She says, to take some of the actions just. Thanks for substituting the most important part of the sentence with real importance, Judge. Thank you. Accepting plaintiff and the state's allegations is true. They say Trump and Elon's actions are thus precisely the executive abuses the appointments clause seeks to prevent. But even a strong merits argument cannot secure a TRO at this juncture. She says, even if you're right, we'll deal with that later. It's not enough here because a TRO requires a very elevated showing of imminent harm. So plaintiffs, the states, she writes, right, this is her little final word, they legitimately call into question what appears to be the unchecked authority of an unelected individual. Like, give me a break. What was Hunter Biden doing in the White House with Joe? Crackhead Joe in there, getting him to sign pardons for his whole family. Where were you guys upset crying about Dr. Jill sitting in the Oval Office desk or Air Force One's chair, acting president, right? Unchecked authority of an unelected individual. They were running the country. You guys just sat there and tried to take out Trump, Judge. So give me a break. And an entity was not created by Congress, and over which it has no oversight. Obama, it was an Obama agency called the DS, the Digital Selective Service, something like that. It must be indisputable that this court acts within the bounds of its authority, and accordingly, it cannot issue a TRO, especially one as wide-ranging as the state's want, which would basically limit Elon from doing anything, and Doge from doing anything. And so the record does not meet that standard. Signed by Tanya Chutkin. Before that, though, she says, and so for the reasons explained, it is hereby ordered that the states, all the blue states, and their pathetic request for a TRO is denied. States lose. Sorry, Chris Mays, read it and weep. It is further ordered that the parties shall meet and confer about further proceedings. If the states intend to move for a preliminary injunction, the parties shall file a proposed briefing schedule, state their positions on consolidating these later down the line on February 19th, 2025. Signed by Judge Tanya Chutkin, same judge who was a disaster for the country when she tried to race through Trump's January 6th case before the Supreme Court took it away from her. She was doing everything possible to try to get that on the books, but she knew she could have gotten convicted in there in D.C. because it's 93% Democrats. So we are still mad at Tanya Chutkin, and what she did was unforgivable, but this was a good decision in that it was the right outcome. She still couldn't set it aside and had to put in there her final little dicta to make her point that it was the right decision. Now, we also had a very similar decision that came out in this case. In the District of Columbia, Doge and Team Trump wins again. You can see this lawsuit was brought by the University of California, the Students Association, and Denise Carter. I'm sorry, versus Denise Carter and the U.S. Department of Education as the defendant sued here. And this is a Doge lawsuit, as we'll see. They're suing the Department of Ed because they're trying to prophylactically get ahead of Elon's bureaucracy grim reaper, going door to door to door. They're down the line, they're like, he's coming! File, file, file! And so they filed this one a while back, but we just got an order for it. So here is what the complaint says, all these students. They say, we want you, Judge, in the District of Columbia to stop Elon. Halt the unlawful, ongoing, systematic, and continuous disclosure of personal info from the Education Department over to Doge. They say more than 42 million people, or 12% of the population, have federal student loans. It's a lot. And for each of these borrowers, they get all sorts of information. They have their social, their date of birth, and more. Education also stores this personal information, and they collect all sorts of information, right? The master promissory note. Many of us know what that process looks like. And they have a giant database. And so people come and they ask for money from the federal government. They disclose a bunch of things, like, why do you need the money? Well, now Doge is coming in, and they're trying to access education system. And that data has 42 million people. And Doge and their affiliated people have no assurances that their sensitive information of their parents and spouses aren't going to be abused, because their actions are shrouded in secrecy. And individuals don't even have basic information about what Elon and I guess the Department of Education are sharing with outside parties. And I think what's pretty flawed in this complaint is they're not suing Elon. They're suing the Department of Education to stop her from transferring information out. And so what is their power to do that? Let's see if they articulate that for us. So the parties, of course, are the students. They say, yeah, education, the Department of Ed, are responsible for managing the system. Student aid is owned by the federal government. All these rules exist. Oh, it's a privacy act. It requires entities to disclose when other people are entering the system, and the National Student Loan Database might have a bunch of information in there, like all of that stuff, and people might access that. So it's a privacy lawsuit, essentially. So they tell us that this is, okay, count one, contrary to the law. So the APA, IRS, and other various statutes say you can't do any of this stuff. So please stop Elon or anyone, any of those affiliated individuals from viewing any of these records, and stop Elon from permitting access, and stop Doge, right, from disseminating any of this.
Hey!
Sure that they don't.
What the fuck did you see, brother? Fucking great. You're a good buddy of mine, man.
With the Public Citizen Litigation Group, which I think we've seen that name before, to stop. Now, that was submitted earlier this month, but the court just came out and issued a ruling, and the students lose. Doge wins. Here's why. The court ruled out of DC, the district court, says, look, the students sued us, and they moved for an order that would stop education and the secretary from disclosing information to Doge. You can't give them descriptions. The students also state that an order should be issued that requires education to safeguard any other information that Doge already got. Now, the judge from Washington, D.C. says, for the reasons that follow, the court will deny the students' motion. Here's why. Each year, Congress provides billions of dollars through loan and grant programs to help pay for students' tuition. The Department of Education administers these programs, and they do require a lot of information in order to get those loans. Now, as a federal agency, education is subject to the Privacy Act and IRS regs. Under the Privacy Act, agencies may not disclose any record to any person or to another agency unless the individual consents or an exception applies. So, this privacy stuff, right? Yeah, that's like my right to privacy. As relevant here, one statutory exception, permits disclosure to officers and employees of the agency, which maintains the record, who have a need for the record in the performance of their duties. Exceptions. I forgot about that. Another that's cited here in the U.S. Code, Section 552A(b)(1), entitled. Another exception permits disclosure for routine use, which refers to the use of a record for a purpose which is compatible with the purpose for which the record was collected. Now, to invoke this exception, an agency must publish notice of the asserted routine use in the Federal Register along with federal categories of purpose and use. Now, the Education Department, they did that. They published, quote, routine uses that are applicable to various databases, which do, in fact, permit certain disclosures. You can see this 89 Federal Regulations 44652, May 21st, 2024, under Joe Biden. It says, for example, education may disclose records in the student database, loan database, to other federal agencies for routine uses. Oh, no. Including to support auditors and program reviewers of the student aid programs. Also, to assist program administrators with tracking refunds and discharges, and to support the investigation of fraud or abuse, or to detect and prevent fraud and abuse. Wow. So even Joe Biden's rules that they passed in May 2024 say you can do all of those things. Isn't that fun? But they sued anyways. Now, the Privacy Act, says this judge, authorizes both criminal penalties and private enforcement for violations. So if you, Rob, have your information stolen or abused, I can sue specifically. I have a cause of action if that happens. And if any officer or employee of any agency, so anybody in Doge, anybody in education, anybody in Treasury, if they access the records and they disclose it, they shall be guilty of a misdemeanor. There's already criminal statutes that exist to penalize this. And in addition, although individual government employees are not subject to civil suits for damages, you can sue an agency for failing to comply if that happens. Now, like the Privacy Act, also, the IRS code also controls disclosure of information outside the government. Section 6103 of the IRS code says that as a general rule, the information shall be confidential. However, upon request of the Secretary of Education, the IRS may disclose an individual's return information to quote, any authorized person, but only for the specified purposes. And so, we know that many of those purposes are broad, reducing net cost of improper payments, oversight activities by the OIG or Department of Ed, and more. And so to enforce these limits, the Internal Revenue Code also provides criminal penalties if you break the law. So here's what happened. On the day of his inauguration, President Trump issued an executive order. It was called the DOGE order, epic. The executive order did three things, writes this DC judge. First, it renamed the United States Digital Service, which was created under Obama, to the DOGE service, okay, and it kept the same acronym. USDS is still USDS. It's just not digital service, it's DOGE service. And established it. Second, it established a temporary organization under U.S. Code entitled the DOGE Service Temporary Org. The executive order provides that there shall be a DOGE administrator established in the executive office of the presidency, charged with heading the DOGE Service Temporary Organization for its 18 months. Pursuant to the law, the head of the DOGE Temp Org may appoint persons to be employees in the temporary organization as required for their skills. So we rename the DOGE service, the digital service, into the DOGE service. Then we create some structure, like an organizational chart, and set an expiration date in 18 months. Then they created the DOGE teams, pursuant to the executive order. The order required each executive agency head to establish in their agency a DOGE team, which will typically include one DOGE team lead, one engineer, one human resource specialist, and one attorney. So all of the agencies will create a team to interface with DOGE. Now, according to the executive order, DOGE's purpose is to improve the quality and efficiency of the government. Why? Oh, it's government-wide. Software, network infrastructure, and IT systems. Now, to that end, the executive order also directs agency heads to coordinate with DOGE to the maximum extent consistent with the law. So don't do anything, agency, that violates your own laws. You know your laws, so create a team to interface with DOGE and follow the laws. And make sure that DOGE has full and prompt access to all unclassified agency records as required. Now, since his inauguration, however, Trump has not formally identified the individual who would serve as the DOGE administrator, is what the complaint says. So, following the issuance of the executive order, DOGE began hiring new employees and working with agencies, including education. There are currently at least, quote, 6 individuals at DOGE, all federal employees assisting with implementing the executive order as part of DOGE's education team. According to this person called Adam Ramada, education is the home agency of 2 of these employees, and the others, including Ramada, are on detail to the department. Ramada said that he and one other employee are also on detail for DOGE, and 2 other employees are on detail for federal agencies. Ramada further says he spends 50 to 60 hours per week working at department facilities, as do 2 other employees whose home agency is the department. Of the other detailed employees, 2 spend 20 to 30 hours per week at the department, and the last spends 5 hours per week over there. According to Ramada, all 6 employees assist with auditing fraud, waste, and abuse. They help leadership get analytics and data. He further appears that he is unaware of any DOGE-affiliated individual other than these 6 people who've been given access to the systems. Now, to date, Ramada, the 6 DOGE employees, have primarily worked to identify contracts and grants that are wasteful and oppose Trump's policies. All but one of the employees has completed ethics and information security trainings. The 6th employee has been directed to complete those trainings this week. Now, lots there. News reports, says this judge, of DOGE staffers and their access to student data prompted the students to sue here, as well as an emergency motion for a restraining order. UCSA is a nonprofit organization, as we know, that has 230,000 students from California, 9 undergraduate campuses, right? organization, more than 70% of their members receive federal financial aid, of course, administered by the Department of Ed, which means that those members have shared interest in a significant amount of personal information with the Department of Education. And they say, if DOGE gets access, we're going to be denied our privacy rights. So DOGE can't actually see those things is what they want. So the U.S., the students seek an amendment stopping education from sharing the data. And they want a retrieval of all the data that's already been shared. Now, the students assert APA, Administrative Procedure Act, Privacy, and IRS, saying that these are the various laws that have been violated. We're suffering, and we're going to suffer irreparable injury. So we need this judge to do something. So now that we know the background, the judge tells us a temporary restraining order is an extraordinary form of relief. It's analyzed using the same 4 factors, and it may be awarded only upon a clear showing that they're entitled to relief. Here are the 4 TRO factors. It's a program in our memory banks. It's likely to succeed on the merits. Irreparable harm if we don't do something. The balance of the equities, and it's in the public interest. So although the students has the burden to show this, we always have to consider irreparable harm. And so the court starts by that. Was or will there be irreparable harm? And because the court concludes that the students' organization has failed to clear that hurdle, we're also going to stop there. We're going to leave for another day, whether there's even standing here to sue, whether they should even be suing here. But since there's not even irreparable harm, we'll just get rid of this case on that basis and call it a day. Those questions are less clear and can deal with those later, but don't even need to talk about it. The D.C. Circuit has set a high standard for irreparable injury. It must be both certain and great, actual, not theoretical, beyond remediation. It's a high bar. But on the students telling, its members, they say they're suffering right now. And they're going to continue to suffer if we don't do anything about this, if their data is accessible to DOGE. They observe that once information is disseminated, they say, oh, the cat's out of the bag. Nothing we can do. And so there's going to be an ongoing injury. Our data will be exposed, and it can't be remedied after the fact. Once it's out, it's out. The students are correct, says the judge, that a disclosure of information generally cannot be undone. But that is not sufficient to show irreparable harm. Now, what the students overlook is that the context of dissemination matters. Courts find dissemination of information to be an irreparable injury when, for example, highly sensitive information will be made public. That's not happening here. Or end up in the hands of someone with no obligation to keep it secret. Indeed, the cases here that you rely on, students, are based on that. All these cases are about being made public and other things. And by the same token, courts have also declined to find irreparable injury when the disclosure is not going to be public, but involved individuals keeping it secret. Here, Ramada says that the 6 employees understand that when they're working in education, they must keep things secret. Anything garnered during the work, we've attested to. He further attests none of the employees will access any tax-related information without appropriate authorization. And all applicable laws and regulations, all of them say they'll follow it. And they also impose strict limits on any disclosure of any of these things made to the public. If they do leak it or disclose it or do something bad with it, charge them with a crime. They'll be civilly liable for it. You don't need to stop them doing their work. If they break the law, then charge them. But they're not breaking any laws. They're following the laws to the T. The students, they cite no authority for the proposition. They say mere access to this is dangerous. It's going to cause an injury because they looked at it. Yeah. What does that mean? If it's going to cause irreparable injury, if they look at it, then that means they're going to find something that's going to be bad for you. Perhaps implicitly recognizing this infirmity, they also suggest that emergency relief is nonetheless needed to prevent future injuries. Like, well, we haven't been injured yet, but it's going to be coming in the future. But we need a TRO now because it's imminent. But it's not occurring yet. They argue that there is a risk, right, which is an if statement, of identity theft. You know, if something else happens, if there's further dissemination, there could be a risk, also very clever, different than like potential. But Also, kind of contingent. Share members' data, it could be a problem. But these harms, however, are entirely conjectural. There's no evidence beyond sheer speculation that would allow the court to infer that those staffers will misuse or further disseminate this information. In fact, the courts must presume that the government will exercise its powers responsibly and with due regard to the affected individuals. The presumption of regularity. We know you hate Trump, okay? But he still gets the presumption of regularity to support the official acts of public officers and their employees, unless you've got clear evidence otherwise. Education and DOJ staffers are obligated by the law to keep this information confidential. Privacy Act, tax laws, other federal laws. He says, Ramada, that all they're doing is auditing for waste, fraud, and abuse. They're identifying contracts that are inconsistent. But none of those initiatives involve any disclosure of sensitive, personal information about you students or anything. The future injuries of your members that you fear are therefore far from likely, let alone to be certain and great. All right, so they're just made up, so relax. Finally, the remedies provided under the Privacy Act and the Internal Revenue Code confirm that the members are not suffering and will not suffer irreparable harm. In general, injuries are not irreparable if there is a possibility that adequate compensation or corrective relief can be available later. If your information leaks, you can sue about that. You'll get paid, you'll be made whole. Somebody will go to jail. Here, both the Privacy Act and the Internal Revenue Code provide a right of action and money damages. Okay, so like you can go sue if this happens to you. You'll have future claims that you can bring if there's unauthorized disclosure. Now, to the extent the students have been injured by a violation of these statutes and they meet the other requirements for relief, there is a possibility of compensatory relief will be made whole later. And so, for the reason above, the student's motion for another temporary restraining order is denied, not granted, so ordered by very astute Judge Randolph, and must be a decision on this one. And this is the appropriate standard to apply to these things. This is what every other District of Columbia judge should have been doing, holding that standard, saying a TRO should not be granted unless there is serious irreparable harm. And what we've been seeing is the opposite of that. They're all just kind of speculating. They all have many other alternative avenues to bring their claims, but the judges just say, we hate Trump, and so we will allow this to carry on, to slow down and drag out the administration. Now, this decision was a good decision, so good, in fact, that Pam Bondi fired off this letter from her office from the U.S. Department of Justice, sent this one from the SDNY into the Honorable Jeanette Vargas. Remember who she is. She is also handling a TRO case. In fact, I believe she granted a TRO. She is this woman right here. Jeanette Vargas, this was the case brought by the other states. So a bunch of other states too here ended up in her court and granted an initial TRO at the outset. So what they're sending into her courtroom was this. They say, hey, judge, you know, this office represents Trump and Elon and the government in this case. And we write to bring your attention to another supplemental authority. On February 17th, the case that we just read from the University of California Students Association denied their motion for a TRO that would have restrained education from doing their job, from disclosing information about plaintiffs' members, the state's members, to individuals affiliating with DOJ, saying they're allowed to do that. We can't stop them from doing that. So, Judge, someone else in D.C. is interpreting this correctly. We hope you do the same. So, very good updates there. And you can see that as DOJ goes door to door and continues to eliminate corruption, fraud, waste, and abuse, people are abandoning ship before they get there. The head of Social Security just called it quits. She's on her way out.
Here's a breaking news for you. The acting head of the Social Security Administration has resigned. Michelle King's departure comes after she refused to provide DOJ staffers access to sensitive information. Your information. King had been with the department for 30 years. It's the latest.
30 years? Good Lord.
Active resistance meant to slow cost-cutting moves by President Trump and Elon Musk, Doge had to go to court to gain access to Treasury payment systems, and it is fighting to enter a sensitive database in the IRS.
So dramatic. It's like we're being taken over by a foreign hacker or something. They're allowed to do it. The federal judge just said that too. There's already other crimes that you can charge them with if they do something illegal with it. It was set up using an agency that Obama created. So stop your hystericism. 30 years from some social security person resigns as soon as they want to look at her books. No wonder she's resigning. And they're going to reframe these as all like, well, she's a heroic person who's going to stand firm to protect your information. She's running away because she's about to get caught, in my opinion. Now, they're having a hard time on this. Even this guy, Mark Elias, you remember him. He was a big player in the 2020 election and the 2024 election. In my opinion, leading a ton of the lawfare against Trump and Republicans. And they're trying to figure out what to do here. Chief Nerd flipped this, saying he's crying because Elon's attacking him or something. Let's listen to what they sound like here.
Look, my life changed after 2016. I was the general counsel for Hillary Clinton's campaign and was a...
Yeah, we saw how you and Michael Sussman and Jake Sullivan tried to rig that election too by creating the Russian collusion hoax that Jake Sullivan posted via Hillary Clinton's ex account. Then you sent Michael Sussman in to collude, in my opinion, with the FBI as you were working with Perkins Coie to lie to them to try to ensnare Trump into some other scam. So no wonder your life changed, brother, because you were involved in my reading of it, corruption in elections.
Prominent Trump critic in that role, and then when he was in the White House. In 2020, as you know, I represented President Biden in defeating Donald Trump and his allies more than 60 times in court after the election to prevent him from stealing it. And I have been involved in voting rights and other disputes with Donald Trump and his cohort for years. So I have become accustomed, unfortunately, it's sick in some ways to say, I've become accustomed to all of the attacks. I've become accustomed to the threats, to the innuendos, to the false smears.
No, they're not false, they're real. You and Norm Eisen are bad actors. We've seen what you've tried to do here, and we're looking forward to all of the exposure coming for you, Norm, Conway, Cheney, and the rest of them. So you can see they're getting a little bit nervous there because scrutiny is coming underway. But the Democrats have not been able to figure this out. One solution to this would be to work with improving the country, try to join the winning team and make the country better for everybody. We do all live in the same country, by the way. It's not outside of the realm of possibility. For Democrats, even like Dean Phillips, right, to be kind of reasonable, to say, look, we absolutely agree there need to be major cuts. We absolutely agree there need to be restrictions on the border. So on and so forth. But we're going to have a little bit of a different approach. We're going to try something. We're going to go all in on this policy, not so good. Actually work with those. Say, volunteer. Here, we got it. We're going to actually the Democrats' budget proposal is going to propose more cuts than the Republicans are going to propose because we're even more efficient and better than you. But they're just so dumb. We need to spend trillions of dollars for foreigners. And this was an interesting exchange on CNBC. This guy, Palantir CEO, is saying they're just not getting it. They're having a hard time, can't wake up.
Look, what I don't like about what's going on is I just view this as, well, let's watch the Democratic Party commit suicide. And like, I've been a Democrat most of my life. I kind of view myself as outside it, but I don't like watching the Democrats just commit suicide. And what I see is most of the country doesn't really, at this point, given the fraud, waste, and abuse we know is there, 90% of the country's like, get rid of that fraud, waste, and abuse. And I just view this as yet another example of the progressive left boxing themselves into a suicide dance. Now, what the progressive left should be doing is saying, okay, Elon, you're clearly the most qualified person in the world to do something like this. We want to dialogue with you about how you're doing, what are you doing. I don't believe that's actually what happened. And again, I think it's obviously the most important thing. And I just think, if you want to say my former side, I don't believe that they're actually engaging. I think it's like another dance where I'm supposed to say, of course, like whatever. It's like there's this one issue where I might, and then you get boxed into you cannot solve the problem. And then I would say, what is the biggest problem in this society? The biggest problem in this society, from my perspective, is legitimacy of our institutions. Why aren't they legitimate? They're not legitimate because, okay, do any of you really believe that 99% of your taxpayer dollars are being spent? But last and not least, and probably arguably most importantly, there's two revolutions happening. One is transparency and one is AI. Okay, so why is it that we do not know where every penny of our money goes? Like, how do you explain that to people? And theft, by the way, slightly more technically, what large language models do is they mean you can go into the contracts and see exactly what happened. So in the past, we couldn't do this. Now we can. The right response is, we want this to happen. We want to have it. We want to be involved in the dialogue. The real response is, it feels like the people criticizing Elon don't want it to happen.
They don't. He's so close to waking up and realizing it's their money. They're in on the grift, brother. 99% of that is going back into their pockets. So why would they want any of it to stop? They obviously don't. Here is another clip. Thanks to Colin Rod for clipping this one for us, saying that Pamela Brown got into it with Tim Burchett, who laid the smackdown on her over at CNN.
Congressman, hold on. I'm going to go into this question because, again, it's not a question of whether waste should be rooted out of the government. So many people agree with that. But now we're seeing it's the way it's being done. The government is trying to claw back several employees who oversaw nuclear weapons after they were fired. They realized, oh, we made a mistake. We need these staffers who oversee nuclear weapons. A professor at the University of Maryland, Don Kettle, who specializes in civil service, told the Washington Post that yes, the government is likely full of wasteful bloat, but said a clumsy fix is worse than no fix at all, saying it's like going to a meat market, getting a piece of steak, and trying to cut out the fat with a sledgehammer. That would only make a mess of the meat. Do you think, Congressman, that is a fair point?
That's a really weird analogy. What?
That the way this is being done is clumsy rather than methodical.
No.
Again, you're attacking the message here, not the results. You talk about nuclear secrets. You had a person who was in charge of nuclear secrets, a man who dressed up as a woman, would go into the airport and steal women's luggage, was overseeing those nuclear secrets under the Biden administration. And I never heard y'all say a peep about that. Again, man.
I don't know anything about that. I'll be transparent.
You don't know anything about the suitcase thief?
Oh, wow.
Dude did it twice. What? Walking out with suitcases. Department of Energy. I don't know anything about that. You should look into it, Pamela.
Elon Musk. You need to look it up. It's all over the internet. It's all over. He was
But the question is, this is unrelated to the people overseeing nuclear weapons being fired. And Elon Musk himself said, we're moving so fast, of course there will be mistakes. The question is, some of these mistakes are really high stakes. Firing people overseeing nuclear weapons. Do you see that point?
Humans will make mistakes, man, but currently these are bloated programs. You have no-show employees that are angry that they're having to go back to work, that they've moved, and they're not.
No one's disagreeing. There's bloated waste.
You are.
No one's disagreeing.
Well, then why are y'all not exposing it? Have y'all talked about, hey, Mozambique, we sent them $10 million for circumcision? Okay. I mean, goodness gracious, man. Americans are
we've been covering at length where the money is going to.
All y'all do is run down Elon Musk and Donald Trump, and you continuously do this, and that's why your ratings are in the tank, ma'am.
All right, Congressman Tim Burchett, we're going to leave it there. I do appreciate your time coming on and having this conversation. Thank you very much.
Yeah, why don't you investigate the circumcisions in Nepal there, Pamela? Why don't you dig into why we're sending millions of dollars overseas for
Hey, Jeff.
Instead of just crying about Elon.
About 10 more minutes, guys, and I'll be out at the job site.
So we actually need that guy. He was good. He was smart. Okay, good. Okay, you can do that. This is
tomorrow night.
Operating quickly. So you move quick, you break things, you fix them, you build the next thing, and you iterate.
Going to a show tomorrow.
That Elon can capture with chopsticks.
Rock opera.
The health. How does that happen?
Tomorrow night.
He knows what he's doing. Pamela doesn't, and that was fun. I mean, apparently she should go do her research on the suitcase thief who was running the Department of Energy before these intelligent people are fixing things. So Senator John Kennedy from Louisiana also came out and had something to say about the Democrats today.
I've got a lot of friends who are Democrats, and they haven't asked me for advice, but if I did, I'd tell them, look, you just got to try harder not to suck. I mean, think about it. Over the past 4 years, the Democrats mismanaged Congress, they mismanaged COVID, they mismanaged the economy, they mismanaged inflation, they mismanaged Afghanistan. More recently, in their opposition to President Trump and Mr. Musk, the Democrats have chosen to support the bureaucrats and the spending over the American taxpayer. Just like they support illegal immigration over the rule of law, just like they support transgender athletes over women's sports, just like they support Hamas terrorists over Israel. All Democrats are not like this, but the party is controlled right now by people who majored in online activism with a minor in puberty blockers. I know these people. They think men can breastfeed. They're triggered by race. They cry if you use the wrong pronoun. And most fair-minded Americans look at this and they go, these people are about 10 exits past normal. And that's what's killing the Democrats right now.
Just try not to suck so bad, all right, Democrats? Gosh, you're embarrassing yourselves. So Senator Kennedy with a nice message for them. Hopefully they learned something, but we're not holding them right there. All right, so let's talk about what's happening with the Supreme Court and the DOJ. Prosecutors are fleeing the DOJ. They're being asked to investigate corruption. They don't want to be anywhere near it. And we've also got the Supreme Court taking action on another person who's trying to weasel his way back into the special counsel's office after he was fired by President Trump. And see, here is what the Supreme Court has for us. Previously, we read through the application that was submitted to John Roberts by President Trump's Department of Justice and the Solicitor General, saying you cannot have Hampton Dellinger, the special counsel appointed by Joe Biden in his final year of his presidency, the same guy who went to law school with Hunter Biden. He cannot be in this office. Trump fired him, and Judge Amy Berman Jackson shoved him back in. So Trump asked the Supreme Court to step in and stop this, and everybody is always looking for what the Supreme Court says next. Like, are they going to deny it? Are they going to accept it? Are they going to order a response? What's going to happen? Well, they ordered a response. So by 2 p.m. tomorrow, Hampton Dellinger needs to respond as to why he should be shoved back into power against Trump's will. This is about the unitary executive and whether the special counsel can be fired unilaterally at will by the president. Of course, we believe the answer is yes. So we're going to keep our eye on this one. Let's see if anything has been dropped since we've been here. And we do have it. Wow. Okay, so this just dropped. All right, so amazing. So let's take a look at what is inside here. So we'll hit the highlights on this one. So this came in, I didn't realize that, so fresh out of the oven. This one just dropped. So Hampton Dellinger submitted his response. So let's hit the highlights on this one, and then we'll see what the Supreme Court does next. What else got filed? So amicus brief, law professors, other people are submitting their briefs. Let's see what Dellinger said in response to this one. So he says, all right, look, to John Roberts, he wants to stay in power against Trump's will. He says the government devotes most of its application to argumentation over weighty and complex issues of constitutional law and remedy, as it is. It's about Article 2 power, right? On its framing of the issues, the merits are everything, and appellate jurisdiction is a mere afterthought. All right, so again, he's going to rely on a technicality. This, you can tell how sneaky this is already. The D.C. Circuit Court of Appeals rejected this twice on jurisdiction. They said you have to go forward, do your preliminary injunction, lose that, get to an appealable order, then you can take it up on appeal. Trump is trying to short circuit that, right? Trump is trying to go right to the Supreme Court. And the dissent at the Court of Appeals in the D.C. Circuit said that when the executive power is being infringed upon, like it is now, because Amy Berman Jackson shoved Dellinger into this position, then the executive should be able to appeal that, because every day that goes by that this guy is in power. Trump does not have his say about who's in power. Do you know who that hurts? Us, the American people. We elected President Trump to go in there and do a job. This judge is usurping that power and not allowing him to do that. Every day is an ongoing harm to us. But he says, look, that gets things backwards, right? So this is going to be a technical argument. In other words, the Supreme Court, you cannot hear this because this has to go through the proper channels. Now, as the D.C. Circuit emphasized, a 2-day appeal from the issuance of a TRO, which was issued 2 days after and which expires later, is not a proper vehicle to resolve these disputes, right? So they're saying Trump should have done something different. But that doesn't stop them. They openly solicit the court to create an Article 2 exception to the general rule that TROs cannot be appealed. And that's not right. It's a president exception because the court is at the base layer. Unless you want us to violate the district level courts and go directly to the Supreme Court or force these things to go to the Supreme Court. In other words, we could ignore the district courts until SCOTUS settles it, which is really what they want, right? That's kind of the impeachment trap. But he's saying no, a lower level district court judge can hamstring the executive branch and the president cannot appeal it. You have to go through the mechanisms so that they can stall out your administration. It's ridiculous. This is actually the opposite. It's like they can use the courts as an exception to executive sovereignty. And any lower level district court judge can just issue a TRO, and then you can be delayed until it reaches the Supreme Court. So he's actually framing it dishonestly in the reverse. It's not an exception. You guys are exceeding your Article 3 power and encroaching on Article 2. But it's sneaky, it's clever lawyering. The government even offers an initial list of TROs it might wish to appeal on this basis, right? Because Article 2 power is being encroached by every one of these TROs. They're quoting Scalia. This wolf comes as a wolf. Thank you for quoting somebody similar to this. For generations, including in 2 untold cases involving government defendants, federal courts have adhered to the principle that TROs can generally not be appealed unless there are preliminary injunctions. So,
It's Tapatios.
again,
I'll be right back. I gotta grab something.
Trump is usurping the standard process. Contrary to the government's assertions, no injunctive relief has been ordered. You haven't forced him to do anything. Remember, because Judge Amy Berman Jackson, didn't call it any injunction. She called it a stay. She was staying the firing. He had already been fired, and she was reversing that. So it's clearly an injunction. So the case does not evoke the special solitude otherwise afforded. And the government has conceded here that it violated a directly applicable statute, which no federal court has enjoined because he didn't give Congress notice before he fired him. He did. They got their notice the same day he was fired. This is the kind of circumstance why TROs are important. And at the bottom, there is no merit to their effort to say there's a 5-alarm fire here. It's short-lived TRO. So this guy can be in office illegally against Trump's wishes for weeks just to preserve the status quo. Separate of those considerations, the government's application should be denied. So just the Supreme Court don't hear this. They say the government's not going to win. There's not irreparable injury if this guy is in office. The balance of the equities cut firmly against relief, and this guy should be made to stay because Trump violated the special counsel statute. We address each of these points and more, and so you can read those highlights on your own. It's going to be a lot of technical stuff in there from Hampton Dellinger, just saying don't hear the case ultimately. So that's fresh out of the oven, but that is going to now be decided by the Supreme Court. We'll be seeing what they say on that one. Hopefully we get some more action on that soon, but we'll also hear more from Trump's DOJ. We should have a reply from them as well. So keep our eyes on that one. Thanks for subscribing and joining as we do. Now, meanwhile, the Department of Justice is also losing other career prosecutors. Boo-hoo. They're racing for the exits, and they're asked to do their jobs. A senior federal prosecutor in Washington resigned on Tuesday. She said that there was an improper by appointees of Trump to launch a criminal probe of a contract awarded under Joe Biden. So he said, look into this case.
It's fucking cold out.
Denise Chung, who supervised criminal cases, in Washington, in the D.C. district, she ran cases. Criminal prosecutors brought 5 criminal in order to open a probe into a contract that she did not identify, and she believed the request was not supported by evidence in a letter that Reuters got. She said, "I've been proud to serve for 24 years. Ugh, good riddance. 24 years as a prosecutor in D.C. During my tenure, I've always been guided by the oath I took to support and defend the Constitution. As a D.C. prosecutor, give me a break." Her resignation letter is the latest. Roughly 20 prosecutors who investigated the J6 cases have also been reassigned right now. Chung said in her letter that at first she was ordered to launch a grand jury investigation into unlawful contracts to Biden. After reviewing the documents, she said that she and her colleagues said there's no evidence for this. And she rebuffed the request, and so now she's gone. Said she consulted with the FBI Washington, another corrupt entity, and is now leaving. She said in a letter she was ordered to resign. She announced her departure early on Tuesday. Okay. So she was fired. Okay, she was fired. Bye, you're fired. Get out. So that's another one. Here is what they're doing in protest. So they've got these little pathetic things that they're trying to do in DC. It would be, it'd be interesting. It's like, if instead of protesting and complaining and whining and just being mostly useless, like if they were productive and worked hard in the government and identified the waste, fraud, and abuse instead of becoming the waste, fraud, and abuse. This position.
All right, y'all. Talk to you later. I'll probably do the backup channel on the way home.
Supposed to be in the office. If you're not at your desk, you should be fired. This is like the display, the manifestation, the literal
XA. Sorry, buddy.
embodiment
Still heading out.
of waste, fraud, and abuse.
Got to Green Springs. I'll fire it up on the way home.
It's been like